In continuing our discussion of trusts of land, in this video what I'm going to do is explain the idea of an express trust of land. We will talk about some of the provisions within statute that relates to the express trusts of land, and then we will also examine one of the major cases in this area as well. We'll look at the creation and regulation of an express trust in land in this video, in this lesson, and we'll talk, like I said, with some case law, examination of some case law, and some examination of some of the basic provisions relating to the express trust of land. Okay, so when we think about an express trust, we have to think back to our previous videos where we've spoken about the idea of a trust. The idea of a trust is the transfer of some kind of property often it is from one person to another or from one organization to another. And this transfer of property is then held on trust for the benefit of a beneficiary. And so within the basic structure of a trust instrument, within the basic structure of a trust in land, an express trust in land, or an express trust in general, you have a settlor or a testator who transfers the property, the legal title of that property, to some kind of trustee, who then holds that property on trust for some beneficiary. We've explained this multiple times already. We have a number of lessons exploring this idea on the Law Academy, on the law of trusts. So you don't need to know anymore, and I don't need to explain anymore. If you want to know more about this, go and have a look at those lessons over on the Law of Trusts playlist. When it comes to an express trust in relation to land itself, it will be created through the use of a self-declaration, and this is done in accordance with the terms of the Law of Property Act of 1925. Section 53(1)(b) of the Law of Property Act says that a declaration of trust respecting any land or any interest therein must be manifested and proved by some writing signed by some person who is able to declare such trust or by his will. This is the provision that is established for the creation of an express trust in land. And when it comes to the various different elements that relate to interpretation of this provision and the way in which the case law has provided and has been provided for this provision, I can point you to the case from 1970 of Pettitt and Pettitt, from 1970. The facts of this case are as follows. This was a case where you have a married couple, hence the names of the claimant and the defendant being the same, with the wife being responsible for the purchase of the matrimonial home and the conveyance of that property being done in her name. So for all intents and purposes, in terms of the legal ownership of the property, the wife had purchased the property, the conveyance was done in her name, she had legal title to that property. They had both, the husband and the wife, had both lived together in the house together, in the property. And when the marriage broke down, the husband tried to make the argument that he had a beneficial interest in the home, owing to the fact that essentially the question of whether or not the husband was able to make a claim for an equitable interest in the property by way of some trust that existed. One argument that was presented related to the improvements and decorations that were performed by the husband. And so if you look back to previous videos that we have done on this topic, if you remember, a lot of these trusts in land issues and questions relate to the idea of there being some kind of married couple or some kind of couple who, or people who are intending to cohabit in a property, where one has the legal ownership of the property. They have the legal title, they have the legal deeds, or whatever it is through which the conveyance takes place. But it is the case that the other person, while not strictly on the legal documentation and is not strictly a legal owner of the property, maybe still contributed a significant amount of the asking price. And so in that regard, an implied trust existed with relation to that, the equitable interest that was made in relation to the contributions to the asking price, sometimes known as a resulting trust. This question here related to the idea of there still being a matrimonial home, which was in the name of one of them in terms of the legal ownership. But the argument that was presented wasn't necessarily that the other person had contributed significantly to the asking price. One of the issues here in the argument was that they had contributed significantly to improvements and decorations which were performed by the husband, and so in that sense that entitled them to some kind of equitable interest in the property. The court held that the decorations and improvements, the argument that was presented by the husband, did not, in and of themselves, give rise to an equitable interest in the property, that there needed to be a little bit more than simply going in and decorating and improving that property in order for there to be an equitable interest to arise out of the establishment of this equitable interest in the property. And so as a result of which the husband had very little to go off in terms of making that and presenting that argument to the courts.